let's go ahead and we'll hop right into talking about jurisdiction and federal court. So it's pretty well known, it's pretty out there. There have been a lot of challenges with bringing family law cases or constitutional challenges to laws and statutes and family codes into federal court. So can you tell us a little bit about your case?
I've spent hours and hours and hours researching this because I got involved in it myself. And so at this point, there are a few people that are more versed in whether you can bring your case into federal court. And you know this, Mark, because everyone's always coming to you and other attorneys saying, you know, I've had it with the state system. The state system just doesn't get it. I want to go to a different system. I want to go to a federal system. But the problem is that most people find out is that generally you can't. I represent Cash Jackson. Cash Jackson is well known amongst our movement. He's one of our loudest voices. We just had a 5.5-day trial. Cash was sort of famous, and I've seen other people do this. Cash tried to remove his case from Lake County, Illinois, into federal court, and just meaning transfer. A removal is like a transfer. So I was saying, all right, see you folks. I'm leaving Illinois. I want to litigate this in federal court. He actually had a lot of good reasons to do it. But the problem is why that's not going to work is that, number one, there are a number of reasons. But
let's take a step back.
Yeah.
For our viewers who have not had the privilege of sitting through an entire semester of civil procedure,
right?
Can we talk a little bit about how it's kind of a technical process?
So there's generally two types of federal cases. There's federal jurisdiction, meaning there's a federal question. There's a federal statute, a law, constitution, something that involves something clearly federal. Okay, a slip and fall at the grocery store is not a federal question. The other part is diversity jurisdiction, where if one person's in another state and another person's in another state, we have a federal forum that's supposed to be neutral. Because in some cases, if it's an in-state plaintiff versus an out-of-state plaintiff, there's a fear that the state court's going to be biased against their own people. So for anything over $75,000, you're able to go into federal court and to litigate basically non-federal questions.
So essentially, kind of simply put, if it doesn't fall into one of those two baskets, it is left to the state. So that's kind of the first hurdle, is you have to make your case fit into one of those two baskets.
Right. And so the problem with diversity is that people could be hearing this and saying, I live in New Jersey and my ex-wife lives in New York. I'll just sue for divorce in let's say New Jersey federal court. That's not going to work. And let's say that you've got assets over $75,000. So let's say that you claim that she owes you $75,000. Let's say you file a tort claim against her, similar like what Sean's doing up in Washington. Then you would have diversity jurisdiction conceivably. But if you're trying to seek a divorce, child custody decree, spousal support decree, or asking a court to divide the marital assets, you're going to run into something called the domestic relations exception to federal jurisdiction. Now, generally, that only applies to diversity cases, but there are actually the Seventh Circuit where I live, which is Indiana, Wisconsin, and Illinois, is the only state that is sort of carved out a little bit where they would potentially apply that doctrine to federal questions. But generally, the law is that if you want a federal court to basically perform the traditional functions of a state court, you're going to get kicked out. So don't even try. Now what you can potentially, and don't try to remove your cases, because first of all, you have to be the defendant, and it has to be less than 30 days. But if your case starts in state court, you're not going to be able to send it up to federal court. So removals, which is a transfer, forget that too. But there are some cases that could potentially get into federal focus, federal jurisdiction, legitimate federal questions. Number one, if let's say you're challenging a state statute, that's complicated. There are other problems with that you could potentially get in. There was a challenge to California's surrogacy law that was challenged in a 2016 case in the Ninth Circuit called Cook versus Harding. A really good case that people should look up, and you'll see a state court or a federal court dealing with a state domestic relations law. There's been, state laws challenged all over the country that involve domestic relations. So you can do that. Now, I think, and this, I can go into how I got into this, but basically for your viewers out there, if you're going to try to get into federal court, you're going to have to go more than likely after someone who's, number one, not a party to your divorce case. More than likely, not positive, but let's say you're opposing counsel, waste of time. Your opposing party, your ex-wife, depends. There have been cases where people have successfully sued for a form of, say, of a tort claim against their spouse in federal court. That's very hard. Like pension issues, I've seen get into federal court successfully, where you're dealing with ERISA law, the pension law, the retirement law. There's a federal element to that. But what you're really going to have to do, more than likely, in order to get into federal court, is you're going to have a state actor come in and injure you. And I think that the most likely way you could do that would be, most obviously, as a police officer. So let's say a police officer violates your rights. CPS, DCFS, okay, Child Protective Services, Department of Children and Family Services. That's what we have in Illinois and California. That is very fertile ground. And there's great people like Sean McMillan in California. There are some people that used to do this in Illinois. We're sort of in a desert. But I think, that I would be, if someone came to me with a case, it would be more likely to be a CPS case where they violated the 4th Amendment or the 14th Amendment, like safety plans. Okay, that you hear and you see these all over the country. They're called all kinds of different kinds of names. In North Carolina, they're, I think, a preventive plan or something like that, where there was a large verdict not too long ago. Let's say if the state comes in and takes your children away without a warrant, without probable cause, without any basis. There's plenty of cases out here where the council will come in and file for an emergency injunction to return the children. Okay, so those are some examples. Possibly a public school. Let's say your children are subject to an unlawful interrogation in a public school. Maybe you could get in there, but in order to get into federal court, you really, you have to find an eligible plaintiff. And right now, as of this moment, it has to be sort of in the outer periphery, that someone who's not connected to your case comes in and interferes with it and prejudices you somehow.
I'll comment on that. So you mentioned the state actor piece. So we hear, I'm sure you're in some of the forums. There's a lot of talk around color of law in 1983. Is that what you're talking about with state actor? Because the vast majority, I don't know if people are really aware, the vast majority of 1983 claims that are even some semblance of successful usually involve law enforcement.
Right. Yeah, this is 1983. 1985 is also conspiracies. Mark, I'm sure you feel the same way. Everyone, especially in family law, hates to hear the word conspiracy. I almost never say it myself. Concerted action is something that I feel more comfortable with. But there is a law that says that if a group of people conspire to violate your civil rights, you can do that. And in fact, there's this great case out of Illinois. Hi, Sean. The Seventh Circuit issued an opinion in 2000 called Brokaw versus Mercer County, in which, in fact, a downstate county, a sheriff, CPS, the judge, all showed up and took these kids away from his parents. And he turns 18, sues them all, and survives 2 motions to dismiss, where they were alleging a conspiracy, and that actually made it through. And that is amazing. Like, I mean, the other way to get standing is to have emancipated children reach majority age and then go back and sue the people that damaged them, including their own attorneys. There have been, and that is solid law, at least where I am. And that case is cited all over the country, neighboring circuits. It's a very influential, important case that any of your viewers, you want to learn about federal law, read Brokaw versus Mercer County, 2007 Circuit Court of Appeals.
I thought you made a couple really, really good points in there. A lot of times when it comes to domestic cases in federal court, you can't necessarily attack head on. It's usually not something straightforward. And I'm sure it's a question you get on a very regular basis. Oh, can I take this to federal court? I want to do this. Most of the time, the answer is going to be no. It's usually, I've seen ones that have actually gotten in where it involves welfare benefits, like I said, CPS, different things like that. But you're probably going to have something unique and probably some administrative body, some state actor involved for it to even be entertained, because the federal courts are going to be looking for a way to kick you out and kick you back into your respective state courts.
For sure.